Hello CA final students, I am back with another revision video. Friends, ये मेरा एक छोटा सा इनिशिएटिव है CA फाइनल स्टूडेंट्स के लिए ताकि आप लोग कम से कम वक्त में मल्टीपल रिविजन्स कर पाएँ और ये मल्टीपल रिविजन्स CA एग्ज़ाम्स के लिए सबसे ज़्यादा ज़रूरी है ताकि हम सारे कॉन्सेप्ट्स को एंड तक रिटेन कर सकें। इसमें हम सिर्फ काम की बातें ही करेंगे जितना हमारे सिलेबस में लिखा हुआ है। सो विदाउट वेस्टिंग एनी फर्दर टाइम लेट्स गेट स्टार्टेड। तो जैसा कि आपने थंबनेल में देखा ही होगा, आज का हमारा टॉपिक है सेक्रा 1956 एंड SCR रूल्स 1957। द ऑब्जेक्टिव ऑफ दिस एक्ट is to prevent the undesirable transaction in security market by regulating the stock exchange market. Firstly, we'll see the non-applicability. The provisions of SCRA shall not apply to government, RBI, local authority, corporation set up by special law, and it is also not applicable to convertible bonds where there is an option to convert this bond at an agreed price. Before we move on to the main part of this chapter, we should first know some important definitions. वैसे तो ICI कभी definitions नहीं पूछता है डायरेक्टली, लेकिन we never know ICI कब खेल जाए हमारे साथ। तो कुछ important definitions है जो मैंने लिस्ट डाउन किया है, वो बस एक बार एग्ज़ाम के पहले देख लेना। Now coming to the main part of this chapter, application for recognition. The stock exchange may apply to CG. The power of CG is delegated to Sebi. So the stock exchange will apply to CG in Form A along with the fee of ₹500. And also stock exchange has to submit the bylaws and rules and regulation. Every application made to Sebi shall contain the following matters. There are 4 matters given here. First of all, it shall contain the details of governing body of stock exchange, its constitution and powers of management. Secondly, the details of office bearer of stock exchange. Thirdly, the details about the classes of member, that is what is the qualification for the brokers, etc. Lastly, if any partnership firm is going to be appointed as a member, then what is the procedure for registration of partnership as a member and who shall be authorized representative. Coming to the next section, that is section 4, which talks about the grant of recognition to stock exchange. If Sebi is satisfied that the rules, bylaws are in conformity, that is they are legal and not illegal, and it is in the interest of trade and public interest, and also the stock exchange is willing to comply with other conditions which might be imposed on the stock exchange in future, then the CG or Sebi may grant the recognition, and once the recognition is granted, it shall be published in official gazette. If any of the above 3 requirements is not satisfied, then the central government or Sebi will not grant recognition to the stock exchange, and in this case, reasonable opportunity of being heard would be given to the stock exchange. Once stock exchange gets its recognition, then whenever stock exchange wants to change its rules and regulations, bylaws, it has to take the prior approval of Sebi. There may be a case where Sebi may conduct inquiries and call for information or conduct inspection before granting recognition. The recognition shall be given in a form of certificate in Form B. This recognition shall be valid for a period of not less than 1 year. The stock exchange shall apply for renewal within 3 months before the expiry of period of recognition, and for renewal it shall be in Form A and the renewal fees shall be ₹200. Next section coming up is section 5, which talks about withdrawal of recognition. If the central government or Sebi is of opinion that recognition granted to stock exchange must be withdrawn in the interest of trade or public interest, then it may, after serving a due notice on the governing body of stock exchange, it can withdraw the recognition of the stock exchange. The withdrawal notice shall be in Form C. But after the withdrawal, whatever contracts were entered before by the stock exchange with the investors or stockbrokers will not be affected. One more important reason for withdrawal of recognition is that stock exchange did not get itself corporatized or demutualized. Once the recognition is withdrawn, it shall be published in Official Gazette of India and also the Official Gazette of the state. Till now, we have learned about application for recognition in section 3, granting of recognition in section 4, and then withdrawal of recognition in section 5. Now, we know that every stock exchange is regulated by Sebi, and so Sebi can now tell stock exchange to maintain the accounts in a prescribed manner and also get its accounts audited by a chartered accountant whenever audit is required by Sebi. Stock exchange also has to maintain and preserve its books of account for a period of 5 years. The members, that is the stockbrokers, is also required to maintain and preserve the books of account for a period of 5 years or 2 years. 2 years is given for the books which are very voluminous in nature. For example, members' contract books, counterfoils or duplicates of contract notes, written consent of clients, etc. Now let us move on to the next section, that is the power of Sebi or CG to call for information. Once the stock exchange is recognized, it will have to submit periodical returns to Sebi. Second thing here is Sebi has the power to inspect books of accounts maintained by a stock exchange at any point of time. Thirdly, the Stock Exchange Board of India may conduct inspection. It may also appoint any person to make inquiry into the affairs of governing body of stock exchange or the affairs of the members of stock exchange. And it shall also be the duty of stock exchange, the governing body of stock exchange, to provide for all this information. So these are the power of stock exchange or CG in this respect. Next, there is a provision of annual reports to be furnished to CG by stock exchange. Every recognized stock exchange is required to submit before 31st January each year about its activity in a particular calendar year. The next very important section is section 7A, that is restriction on voting rights by stock exchange. When the stock exchange want to restrict its voting rights, then it will have to take approval from Sebi or the central government, and then it can do so. It may also provide for the restriction of voting right only in respect of matter placed before stock exchange. It may regulate the voting rights in such a manner that each member shall be entitled to one vote only. The member shall not be allowed to appoint any other person to attend or vote by proxy. The next section is section 8, which gives central government or Sebi the power to make rules or amend rules. And the recognized stock exchange has to follow within a period of 2 months from the date of the order. And if the recognized stock exchange do not comply with the order, then the central government or Sebi shall forcefully make or amend the rules, and it will be deemed that the amendment has been made by stock exchange itself. The next section talks about the power of stock exchange to make its bylaws. Any recognized stock exchange can make its bylaws for regulation and control of contracts. This requires the prior approval of Sebi, and then this will be published in the Gazette. Section 9 was talking about the making of bylaws by stock exchange itself. The next section, section 10, talks about the amendment in the bylaws of stock exchange by Sebi. Sebi may either on request or suo motu may amend the bylaws made by the Sebi. In a case where stock exchange objects to the amendment of bylaws by Sebi on its own, then recognized stock exchange may apply to Sebi within 2 months of publication in Gazette of India. Section 11 talks about superseding of stock exchange, that is to override stock exchange. CG has the power to override the governing body of stock exchange, and if CG thinks that the governing body of stock exchange should be superseded, then CG may serve a notice to governing body of stock exchange and appoint person to perform all the functions. Section 12 gives the power to central government to suspend the business of recognized stock exchange for a period not exceeding 7 days. This may be extended if it is in public interest. The next section coming up is section 15, which talks about members not to act as a principal. No member shall enter into a contract as a principal. If a member desires to enter into a contract as a principal with a non-member, then he has to get a written consent from the other person. If the consent is not in writing, then he shall secure the consent within 3 days of the contract. Also, the contract note shall indicate the member is acting as a principal. The next section is section 27, which talks about the title to dividend. If a company has declared dividend and during this period the shareholder has transferred its shares, then in such a case, transferee needs to apply within 15 days of the date when dividend becomes due to claim the dividend, and then the transferee shall have the right over the dividend. Otherwise, the transferor shall have the right over the dividend. The period of 15 days may be extended in case of death of transferee, or in the case of loss of transfer deed by theft, or in case where there is a fault of post, that is causes connected with post. Friends, this section is very important as ICAI has asked many questions related to this. Section 27A and 27B is also same, like this only. The next topic is delisting of securities. A recognized stock exchange may delist the security after recording the reasons on any of the grounds which is prescribed. The alleged grounds have been stated in Rule 21. You know what? This question has been tested by ICAI in November 20 paper, and so it becomes an important question. Let us have a quick look over this rule. We will here discuss only 4 of the grounds. The first ground is company has incurred losses during preceding 3 consecutive years and it has negative net worth. Secondly, the trading in securities has remained suspended for a period of more than 6 months. Third ground is that the securities of company has remained infrequently traded during the preceding 3 years. And lastly, company or any of its promoter or the directors have been convicted to comply with the provisions of the Act, Sebi Act or Depository Act, and has been awarded with a penalty of at least 1 crore rupees or an imprisonment of at least 3 years. Here we come to the last topic, which is the appeal provisions. Appeal shall lie to Securities Appellate Tribunal. Whenever any person is aggrieved by the order of Stock Exchange, Adjudicating Officer or the order of Sebi, then it may appeal to SAT within 45 days, which may be extended on sufficient cause, and this shall be disposed of within 6 months from the date of receipt of appeal.